Hi, I call this very brief video tutorial So You Want to Fight. It's essentially about alternative dispute resolution techniques. Years ago, when individuals had a conflict or a problem amongst themselves, they would quite often decide to settle the matter through violence. For example, they would duel in a field, or they would basically each consent to a fight, and that would be seen as a way to properly settle a matter in dispute. Well, then traditionally, a more formal method evolved over time, and that was essentially bringing a matter before our legal court system. Now, there's an alternative to dealing with matters through lawsuits in the courts. Alternative dispute resolution affords us various options in dealing with a dispute amongst parties. Parties can always negotiate a solution, and that's probably the most preferable way to settle a dispute. Now, most lawsuits are actually settled before the matter proceeds to a trial. I would say, in my estimation, about 98% of cases settle, and a lot of them at the last moment. There seems to be a lot more pressure to settle before the matter proceeds to court. Now, a settlement really represents mutual agreement with respect to a solution, as opposed to a court-imposed one. In deciding whether you want to proceed with a legal dispute, you may want to consider a wide variety of factors. Number one, what further steps are necessary and how long will they take if you decide to go to court? Can you devote the resources, including money, and the energy required to substantiate a lawsuit before the courts? Will the dispute affect your reputation? Is the relationship with the other party valuable, and will it be harmed if you proceed to court? Are there important legal principles you want to establish in terms of setting a legal precedent which could occur if a court makes a decision? And if the matter does proceed to court, what's the likelihood of winning? And the last thing you might want to consider is, if you do win in court, can the judgment be enforced against the defendant? In other words, does the defendant have enough assets so that you collect on the judgment? Now, mediation is a form of alternate dispute resolution, and it tends to work well with parties who are willing to compromise rather than parties who want a winner-take-all attitude. It's basically a negotiated of a settlement with a mediator. Now, some contracts require that mediation be used if there is a dispute, and some courts also require that mediation be used before a trial begins. And if that mediation doesn't work, then the matter will obviously proceed to trial. Now, arbitration is another form of alternate dispute resolution. It's where a third-party decision maker makes a decision binding on the parties, much like a judge does, except that it's a much more cheaper alternative than our traditional court system. Now, litigation is the formal and more traditional way of solving a dispute involving our court system, and these courts are created and administered by the state. It's very costly to start a lawsuit, and it can take at least up to 7 to 10 years to receive a judgment. And when I say a judgment, I mean a final judgment that works its way through the various levels of appeal courts. Quite often it can take 7 years for a matter to be heard by the Supreme Court of Canada. So now, when you do get to court, it's one thing you have to really know, that if you're the plaintiff, generally it's your responsibility to prove your case. Okay? You bear that burden of doing so. And a judgment can also be appealed to a higher court. So if you win at trial, the loser party can take it to a higher court, which will review the decision and may render a completely different decision. And that means you may only resolve the matter in a final sense when the matter is decided before the Supreme Court of Canada. A very costly and lengthy process. Thank you very much.